Hi there, I'm attorney Kelly Longtin from Kelly Longtin Law, where we provide effective estate planning for everyday families. And in today's video, I want to talk to you about why you may want to avoid intestacy. Now, about 2 out of 3 Americans will die without a will, and that's known as dying intestate. While the reasons for not having a will vary, the end result is the same for everyone. They do not get to choose who receives their property when they die. Instead, their money and property are distributed according to the laws of their estate in a process called intestate succession. Now, this is not necessarily a bad thing. In most states, a person's spouse, children, parents, and siblings are given priority in the line of succession. But even if someone is fine with their next of kin receiving all of their money and property, a beneficiary can still be required to go through a long and costly court process when there is no will. Now, state law can only assume how the typical person would dispose of their estate. When a state's default intestacy laws do not align with the actual preferences of the decedent about who should get what, this can lead to a number of issues. Now let's talk about potential consequences of dying intestate. Now, state intestacy laws, while largely similar from state to state, vary in the details and can quickly get complicated, especially when a family is blended and does not have a typical nuclear structure. In fact, because more than half of marriages now end in divorce, most families have shifted from having a biologically bonded mom and dad and kids to a blended family structure. Default intestacy laws can leave out not only stepchildren, foster children, and children placed for adoption, but also close family friends, charities, and others not related by blood. Now let's talk about the issue of who receives the money and property and just how much. Intestacy laws are rigid about who receives how much. Intestate shares are statutorily determined and do not consider special circumstances, such as an heir who is receiving income-based financial aid and may be disqualified from further benefits due to an estate disbursement. This could be avoided by placing money and property in a trust for that individual's benefit. Now, parents commonly divide their money and property equally among their children, but no law requires this, and there are no good reasons, there are good reasons why some parents do not want equal distributions. State intestacy laws preclude unequal distributions, as well as intentionally disinheriting a child. And there's lots of other problems as well. All of these special circumstances require nuance in an estate plan, but state intestacy laws are not nuanced. Intestacy can also give rise to the following issues. Some loved ones are unable to make specific funeral arrangements. The probate court chooses a personal representative to manage the estate who may not be somebody the decedent would choose for that role. The court decides who will raise minor children. Small business owners can lose control of what happens to the business when they die. Property that the decedent intended to keep in the family could be sold. The probate process can be lengthy and delay how soon loved ones receive money and property. Probate costs can drain money and property that otherwise would have gone to heirs. Arguments can break out between heirs about what the decedent would have wanted. Digital assets like social media accounts and fintech accounts could be left in limbo. And there are no instructions for end-of-life care or incapacity. To clarify, not all accounts and property pass through probate when somebody dies without a will. Some accounts and property bypass the whole probate process and the court system in and of itself. And that includes those jointly owned with survivorship rights, accounts with beneficiary designations, and transfer on death and payable on death accounts. Anything owned by the decedent in their name at death without a beneficiary designation will have to pass through the probate court and is subject to intestacy laws. You don't want to leave your legacy up to the state in which you live in. There is much about death that we cannot control. We do not know when or where or how we will meet our end, but we can control our legacy and make our final wishes known through an effective estate plan. Now, there are many reasons for not making an estate plan. You may think that you're too young, you do not have enough money and property, or you can't afford estate planning. But a better question might be, can you afford not to have a plan in place? A basic estate plan can fit your budget and allow you to rest easy, knowing your money and property will end up where you actually wanted them to go. So don't leave your legacy up to the state in which you live. Create an estate plan while you still can and make your wishes known. I want to thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law, where we provide effective estate planning for everyday families in Massachusetts and New Hampshire.